Okay, Mr. Blumberg, are you able to hear me okay?
I am, Judge. Thank you.
Okay. Okay, we've got Mr. McPheron's counsel connected, so we'll go on the record. This is Jam Exploration versus Matthew McPheron. This is file number 2520089-AV. This is an appellate matter, an appeal from a district court dismissal of the plaintiff's complaint. If I could just have both counsel put your appearances on, please.
Thank you, Judge. Good morning. Elliot Blumberg on behalf of the plaintiff appellant, Jam Exploration.
Good morning, Your Honor. O'Day Merway, P76460, on behalf of Mr. McPheron, the appellee.
All right, thank you. This is the date set for oral argument in this case. First of all, I just want to say I appreciate patience of the parties here. We're getting started a little bit late. That's my fault, but I appreciate everybody's patience in getting started this morning. Just so that council's aware, I did have a chance to review the lower court file. I had a chance to review the orders that were entered. The transcript from the hearing back on February 24th of 2025, the briefs of the parties, obviously. So I'm pretty well versed in the arguments and the facts, as well as the district court's basis for its determination. So with all that being said, Mr. Blumberg, is there anything that you would like to present today by way of oral argument?
Yes, Judge, really, there are two issues I think that are really before the court today. One of them is obviously the dismissal of the summary proceedings that was brought in the 87A District Court against Mr. McPheron. I mean, I think the court is pretty clear what the facts are. Mr. McPheron had entered into an agreement with Jam Exploration to rent some property with the option to purchase that property. When Mr. McPheron stopped making the payments, summary proceedings were commenced in the district court. The matter was first initiated with Judge Cooper on the bench. That's how old these cases are. And then Mr. McPheron sought to disqualify Judge Hesselink at one point in this case. That was also resolved in a proceeding before the Judge Hesselink. Mr. McPheron had filed an answer, or at least a response to the summary proceedings by filing a motion to dismiss. That matter was not heard by the judge. We objected to the filing because it failed to comply with the requirements of the court rule, and he didn't file a brief, and he really had no legal authority, and was perhaps even not clear the basis that he was seeking a dismissal. So the matter was adjourned. Mr. McPheron was given an additional 30 days to amend his motion. And when we came back to court, he was asked by Judge Hesselink, have you filed your amended motion? And he acknowledged he had not. So at that point, I was under the impression the motion was going to be dismissed. Curiously, though, Judge Hesselink took it upon himself at that point, first of all, to acknowledge that the amendment hadn't been prepared, but then took it upon himself sua sponte to determine that the document that gave rise to the legal action was a land contract as opposed to a lease with an option to buy. I really wasn't provided any notice that that was even up to be discussed, but he made his ruling from the bench sua sponte and determined that our remedy was to refile a breach or a land contract forfeiture or foreclosure action. We had respectfully at least indicated that we didn't believe the court was correct, that its reliance on a statute was also in error. And again, more importantly, I wasn't even really provided an opportunity to file any response to the court's sua sponte motion. We filed a motion for reconsideration. The judge basically took the position that it was simply restating the same issues that had been brought up before the court. And again, that I think was also clear since we never had the opportunity to bring the issues before the court. So the first issue is, Judge, did the court commit error by simply sua sponte making the determination that the document at issue was a land contract? In our brief, I think we've clearly pointed out the terms of the agreement really is a lease with an option to buy. The language in all of Mr. McPheron's documents talk about the steps that need to be taken before he can exercise the option. The first and perhaps the primary step was he had to make all the payments under the terms of the rental agreement. If and when that ever occurred, he had to submit in writing his decision to exercise his option. Again, he never did that. In fact, he never got so far on any of these properties because he never made the payments. So it's pretty clear to me, and I'm not exactly sure why the trial court thought that this was a land contract. He does not have any type of equitable interest in the property. He is no different than any tenant that merely is attempting to rent the property with an option to purchase. Again, it's our position the option was never properly exercised. And I've kind of put both of our arguments before the court at the same time. Again, just to clearly restate our position, we think the trial court erred by dismissing the case, allowing the motion to dismiss to go forward, even though it failed to comply with the requirements of the court rule. He failed to respond to the court's direction to amend his motion. And beyond that, again, I think a clear reading of all of these documents are that they're not a land contract. I think I had pointed out in the past I was not the drafter of these documents. They certainly wouldn't have been drafted in a manner that I would do, but it doesn't in and on itself, on its face, create any type of equitable interest in the property. Mr. McPheron also violated the express terms of the property of the agreement by placing a structure on one of his properties without getting written permission by the landlord. So if the court has any questions, I would attempt certainly to answer that at this point.
No, I thought your brief set forth your arguments very clearly, and your argument here today is consistent with the brief. So I don't have any questions. I may have some after I hear from Mr. Meroway. So Mr. Meroway, any oral argument you want to present on behalf of your position here today?
Thank you, Judge. I appreciate it. And it's good to see you today. And thank you for saying my name correctly, which I'm not sure how you did, but I appreciate it. You got it right.
I just listened to you really closely, so.
Believe me, that's not no one gets it right. So I appreciate it. But with regards to this case, saying that it's clearly a lease option to purchase is really stretching the word clearly there. Let's start with a couple of things. First, he started off by saying his issue here was the dismissal at the summary proceedings, and he said the facts were obvious. The facts were that it was a rent with an option to purchase. That wasn't a fact, actually. That was a legal conclusion made by the judge. The judge, sua sponte, correctly made a ruling that it was quite obviously a land contract and it was brought incorrectly. That happens all the time in landlord-tenant proceedings where somebody brings an incorrect pleading and it's quite obvious on its face, which the judge reviewed the contract and was able to see on its face that it's obviously not a lease option, despite the fact that the title says that it's a lease option on one or two of the pages. There is a mortgage, it's a mortgage. There's an amortization schedule. He's paying interest. He's paying taxes. This is clearly not a lease option to purchase. In fact, one of the things that Brother Counsel mentioned was that there were steps needed to be taken to exercise the lease option. And those steps were, and I kid you not, paying the rent, meaning he has to pay his mortgage payments in order to exercise the lease option. It's not the way that works. Lease options have specific terminology that says that the tenant must exercise the lease option by stating in writing generally that they are exercising their right under the lease option. In fact, the two cases that Mr. Blumberg cites to are very explicit about the fact that the tenant didn't expressly follow the terms of the agreement to say that they were exercising their rights under a lease option. So here, just paying the rent doesn't make any sense as a way of saying that that's that's the terms that needed to be fulfilled for a lease option. No, in fact, this was, as my brief stated, if it walks like a land contract, talks like a land contract, it's a land contract. This has all the makings of a land contract. And trying to circumvent the rules with regards to foreclosures by doing an end around and sending a 7-day notice and trying to go about this as non-payment of rent is exactly why the Michigan legislature created this whole dichotomy. And Mr. Blumberg mentioned he did not draft these documents, and he would not have drafted them this way. I asked why. Why wouldn't he have drafted them this way? Because it's obvious. Theirs are terribly written by someone who doesn't understand the difference between a land contract and an option to purchase, but put all the terms of a land contract, all the necessary parts of a land contract, and then try to style the document as a lease option so that they can get the best of both worlds. But that's not how it works. And the courts look at the document on its face and they go beyond the title. And that's obvious under the case law I mentioned. And this court can do that. And the district court did that. In fact, they denied the motion for reconsideration, having heard all these arguments probably multiple times, because they recognize that this is quite clearly a land contract. Mr. McPheron's rights need to be respected in that regard, and that they need to go through the right proper channel to foreclose these houses. And if there are any questions, Your Honor, I'd love to answer them.
I do not. Mr. Blumberg, as the appellant, anything that you wanted to argue in response to Mr. Merway?
Again, Judge, I think that Brother Counsel has failed to even address the proceeding that resulted in the dismissal. I can't emphasize it enough. We were there on Mr. McPheron's motion, which was not granted, or at least on its face, he was told he didn't comply with the court rules. The court rules are specific. On a summary disposition motion or a motion to dismiss, you have to clearly specify under what section the motion is being brought. The same court rule talks about the necessity of having a brief filed whenever there's a question of law that needed to be addressed by the court. Mr. McPheron, understanding that he was unrepresented, was told a month earlier he needed to comply with the terms of the court rule. So procedurally, the ruling of the court, I believe, was inappropriate. I was not given the opportunity to respond to the court, and certainly couldn't provide the court with any legal authority, given the fact that it was a surprise that the court was taking it upon itself to make the decision that it did. But aside from the procedural shortcomings brought by Mr. McPheron, I think the fact of the matter is that this document, this series of documents, give it very clear direction as to what needs to happen if Mr. McPheron seeks to exercise the option to purchase. And it states clearly in black and white what those steps are. First and foremost, it requires the payment, the rent payments, before he can exercise the option, which he is required to exercise in writing. I don't think there's any disagreement that the law in Michigan talks about clearly anytime an option to exercise an option to purchase, it has to be in writing and notice has to be given. Mr. McPheron didn't do either of those things. So with all due respect to counsel's argument, this isn't a land contract. This is a lease with an option. And we would ask the court, I guess the remedy that we're seeking is to send this matter, remand it back to district court to continue the summary proceedings. That's what we would be asking the court to do today. Thank you.
Okay. All right. So again, I read through all the arguments of counsel. I had a chance to research the law cited by each side. Again, read through the transcripts. I'm familiar with the district court's basis for its decisions in this case. The arguments of both sides have been largely consistent with their arguments in writing here today. First of all, looking at the standard of review, again, this is before this court as an appellate issue. And I think there are a couple different standards that apply here, because I think there are kind of mixed questions of law and fact. As both sides have correctly indicated, questions of law are reviewed de novo. in my view, this involves kind of a combined question of, is this, or did the district court err in finding that this was not a lease with an option to buy or a landlord-tenant situation subject to summary proceedings? And then if the district court was not in error in making that determination, did the district court err in dismissing the action based on procedural grounds and what I view as a lack of subject matter jurisdiction? And subject matter jurisdiction is a question of law, contract interpretation is a question of law, application of facts to law or mixed questions of facts and law are reviewed for an abuse of discretion. So first of all, looking at the contract at issue, which I reviewed very carefully, I read through a number of times as the governing document in this case. And based on my review and looking at the district court's basis for its ruling, I agree with the district court that we're not dealing with a lease with an option or a landlord-tenant, lease situation. In my review of the language, it's clearly contractual land contract type language. I think, Mr. Blumberg, you're in kind of the unenviable position of having to deal with poorly drafted language. I think, as we've all acknowledged, in terms of if this was meant to be a lease with an option or a lease situation, it certainly was not properly drafted and didn't have language in it, I think, that would be required to keep it in that realm. And so, Mr. Blumberg, you've been kind of placed in a position of trying to argue with bad language. And I'm quite certain that if you were helping with this transaction, that you would have drafted it much more clearly than it was. But all of that aside, I don't think the district court erred in concluding that this was not a lease situation or lease with an option to buy. And that led to the district court, I think, to its next finding, which is if that's not what it was, then it didn't have, the district court did not have jurisdiction over that action and dismissed it. And that leads us to Mr. Blumberg's kind of procedural argument. Once the district court determined that this was not a lease situation or a lease matter governed by a statute that would keep it within the district court's jurisdiction, I think Judge Hesselink determined that he didn't have subject matter jurisdiction because it was more in the nature of a breach with jurisdiction in the circuit court. And looking at it in that context, I don't find that there was an error in the district court sua sponte making that determination that this was not a lease that he would have had jurisdiction under and therefore dismissing it. Courts are bound to take notice of the limits of their authority, and a court may and should, on its own motion, even if it's not raised by the pleadings, by parties or counsel, recognize a lack of jurisdiction and dismiss their case. And that's Henry Frazier, 288, Mich. 392, 1939. Courts are required to confirm subject matter jurisdiction either when there's a challenge by a party or sua sponte. And so the district court had the right and arguably, I think, a duty to address whether or not it had jurisdiction based on its reading of the contract language and the limits of its jurisdiction. And so, again, the court finds that Judge Hesselink reviewed the language, determined that this was not a lease, and therefore could not be the subject of an action recognizable by the district court. And however, inadequately or inartfully raised by Mr. McPherson, Judge Hesselink had, again, arguably a duty to raise that issue himself, even if it hadn't been raised at all or improperly raised. So the court finds no error in either determination. And so the court will affirm the ruling of the district court, with the exception, and I think this is important to recognize, and I looked at the district court's orders, both on the motion for reconsideration and the initial order of February 24th, dismissing the action. I think it's important to note, and I make it specifically part of my findings, that the district court's ruling is affirmed to the extent that that ruling is without prejudice. So in other words, I don't think that ruling in any way cuts off Jam Exploration's ability to seek enforcement of its rights under that agreement. Again, I think, in my view, I view this as much more of a dismissal for lack of subject matter jurisdiction in the district court, which would be without prejudice, and that there wouldn't be any kind of, collateral estoppel or anything preventing Jam Exploration from pursuing its rights under that contract. So that is the ruling of the court. Mr. Blumberg, as the appellant, I would just ask that you prepare an order reflecting the court's determination today.
I will do that. Thank you.
Okay.
Thank you very much.
Thank you.
I appreciate it so much.
Yeah, that's all for the record today, and all parties are free to disconnect at this time.
Thank you, Your Honor. And your staff was great to work with in the